Oh, thank you, Tiffany. This workshop is on contract essentials for artists, and it is part of our Artswell programming. For those who have never been to a Triangle Artworks program before, know that the work we do, we're a nonprofit, and the work we do is that we serve the arts as a business sector here in the Triangle and actually growing across the state. And what that means, serving the arts as a business sector, what that means is we create programs like this, like our Artswell workshops, with short form workshops like this and our long form workshops, as well as networking events, peer support events, online resources, all the resources we can create to help people working in the arts thrive as businesses. So, and as I said, a big part of that is our Artswell programs. We have with us today Tiffany Coley, who is our Artswell program coordinator. She's going to be off camera and running everything from the back. I, as director, don't usually, hi, Tiffany. I, as a director, don't usually get to participate in Artswell programs, but because I am a lawyer, they let me moderate the probably against their better wishes, they let me moderate the legal programs. And so I'm glad to be here today. And give me a second because I want to get so I can see for some reason. Oh, there we go. I was being distracted by my screen. So we're very excited about our program today. We have two amazing lawyers that have been sort of friends of our organization for a while. For those of y'all who have been to our SMASH event, both Charles and Peter have been subject matter experts at our SMASH event for last 2 years, and both of them very popular. So we're glad to have them here in this program today. Just a couple housekeeping things before we get started. As I said, if you have a question, and we're going to go through the content and not take questions till the end, and hopefully have a discussion, a bigger discussion at the end, and allow time for all your questions, but it'd be easier if you put them in the chat for now. And one thing we have to say before we get this started is that nothing that is said today constitutes legal advice, and nothing that is said today creates an attorney-client relationship between you and these lawyers, and because, Triangle Artworks insurance is not that great. So we want to make sure you all know that this is merely informational purposes and not legal advice. This program is also being recorded, as I think you all know, and as you heard a minute ago, as a lunch and learn. Like all our lunch and learns, we record them, and that enables us to then put them up on our YouTube page, which is called Artswell TV, so that you or anyone else can access them at any time. And I think I'm gonna admit some more people. Make sure everybody's in before we get started with content. I think that's everybody. Yeah, thank you, Tiffany, if you don't know about Triangle Artworks, you can hit this QR code and you go to our website and find out a lot more about us. But I'm going to go ahead and get started with the content. So contracts are a continuing concern for artists, and we get a lot of contract questions. So we wanted today to talk about both give our attendees the basic knowledge of what you need to know about contracts, like what is a contract, when do I need a contract, what are the elements of a contract, and also talk about some tips and strategies for what to do when someone hands you a contract, what to do in negotiations, and that sort of those sort of questions. Charles Sexton is going to be kicking the discussion off and talk to you a little bit about what you need to know about a contract. And Charles, I think I'm going to let them introduce themselves and tell you a little bit about their work. Over to you, Charles.
Good afternoon. Thank you so much for this invite. As she said, my name is Charles Sexton. I am one of the partners at Unoya Law Firm. We have an office located here in Cary, North Carolina. For me, this is special because I have been in the arts all my life, essentially. Growing up as a preacher's kid, in the choirs, then going into school, um, playing the saxophone, and then um, learning vocal performance in undergrad and recording projects. And now I am in the stage where I'm able to provide legal services for my clients in the fields of entertainment and the arts. So I've worked with production companies, singers, producers. For myself, I essentially tell them that as an artist, they are part of a business because you have to know the important parts of the business to understand where your responsibility lies. So for me, I have a joy in catering to all the needs of the artists. In a business mind for its same, giving them all the tools and tips they need, and also give the emphasis on intellectual property because that's also where I think that's it for now.
It, do we lose him?
Can you hear me?
I do now.
Okay. All right. You want to start off with the beginning slides? All right. So for me, we're going to talk about from the basic parts of a contract. So I'll uncover the foundational pieces of what it means to have a contract. So we can start with the first slide. So why does having a contract matter? For me, a contract is the foundation to several professional relationships. It protects your rights and your work. You never want to ask someone, do I own this? Is this mine? How much am I getting paid? You always want to have that information in a document to read, to sign, to understand. Having a contract avoids misunderstandings or disputes. It ensures that you get paid because, of course, your work is priority. You love your work, but you want to get paid for the things you do. So having a contract ensures that you get paid. And on top of that, it ensures that when you have a contract in mind, this is what I want to do and I'm serious about it. And it emphasizes that here, a handshake is never enough. You want something definite, something substantial to ensure that you are creating a real professional relationship. So, why are contracts important in the arts? Well, you want to know where your art is going once you send it off, once you provide the service. Like I said, you never want to question where your work is going, who owns it. And my personal preference is that it shows that you're serious. You're providing a documentation, signing documents stating that this is what I'm responsible for, this is what the other party is responsible for. Would you rather defend your position based on the terms of a contract or promises of a third party? What would be easier in this situation? I'd say definitely having a contract and arguing your rights to a contract is much more easier to defend in court versus telling a judge, well, they told me that I would get paid $50,000 when I sent them my 5 pieces of artwork. And you understand that your work is important and it's something special to you. But as attorneys, we are here to ensure that you have all the components in place to keep your work yours and help you earn more money for the work that you do and which you provide to others. So, what is a contract? Essentially, a contract is a legally binding agreement between at least 2 or more parties. In short, it is a mutual promise. You agree to do your part, which is creating the artwork, performing or delivering a service, and the other person agrees to do theirs. So that's paying you, giving you credit, or providing resources. As long as everyone agrees to the terms and understands them, and it gives you something of value, it can be legally binding. So there are parts um, to consider in a contract when you're making sure that it's valid. Part one is that it needs to be voluntary. You have to have the intent to enter into a contract. If, as an artist, you are forced or tricked to sign an agreement, you can argue that essentially that can't be an enforceable contract. You have to know what you're signing. You have to know what you're getting into before you can say that you are placed into a legally binding agreement. Secondly, it has to be mutual. Like I said, you both have to agree. So if there's a misunderstanding as to what you're agreeing to in the contract, you may have to go back to the drawing board as to what are we really getting into in this agreement and what are our obligations separately. Another thing to consider is that you have to have the capacity. You have to understand that this is a formal agreement between at least two parties. And for reference, as an artist, when you're getting into contracts with individuals, ensure that you cannot go into a contract with a minor. So for artists that are below the age of 18, there may be conversations that you're having with their parent or guardian in regards to their rights, where the guardian has to step in and to help with that third party understand what this relationship is. And making sure that it's enforceable. You want to make sure that all the parts of the contract are there. So that way, if you have a question or concern in regards to how the contract has been implemented, you have those rights to argue in court. So there are three pillars of a valid contract. And I feel like a lot of people have heard these, but I call them pillars because they are the foundational tools to ensure that you do have a valid contract. So, first part is an offer. Simple enough, it is the proposal. What is being given to you? What is being asked? Who is requesting something of you, and what are they giving to you in return? Acceptance. This is when you say yes to the offer. It can be written, spoken, but you have to go into consideration. Consideration is the exchange of the value. It is what are you giving up to receive something on both sides of the agreement. So we can start from the offer. So, as we said, offer is the proposal. It is the opening door to the contract. Yeah? So, how do you know if an offer is real or valid? It has to be clear. You have to know what they're requesting of you. It has defined terms and that has an intent to have an offer. So, for instance, I have examples. I'll pay you an album cover for $500 due before the release date. This is giving the buyer the idea of if I pay $500, I in turn will receive an album cover. The artist is the person that is providing the work. So the offer is if you give me your work, your talent, and provide me this product, you in return will receive $500. I had a previous client during the pandemic. He was going and back into the lab, is what he calls it. He's an artist. He was working on music, and he decided to start posting a lot of his sound clips online for everyone to see because he just figured everyone's stuck in the house. Let's see what I could do about getting my music out. A few months later, there was an up and coming artist who just kind of hit mainstream at the time. That mainstream artist contacted my client, and they started having conversations through social media, just talking about how they loved each other's work. And that process, that up and coming artist emailed my client with some information and said, "Hey, I think we would be great working together. I think we can move this forward and let's get some details about how this works. So, if you sign this agreement and pay me amount of money, I would be willing to be a part of a song as a featured artist." At the time, the client didn't know what to expect. So he called me first and foremost, excited. "Oh my God, I have this great artist that has contacted me. What do I do?" First, don't say anything yet. This is the opening door because he's offering you to have a collaboration of talents on a record. However, you need to determine, hey, let's see this agreement, and you have to be sure that you are able to pay this individual. You also, as an artist, you have to understand that sometimes when you hear some of these responses, you have to think, is it an offer or is it an invitation to offer? You have to be mindful of what is being asked of you and what are the terms. If the terms are not defined and it's not clear, always ask questions before you accept something. So if there's a need where someone, you feel like they're offering you something, you ask for details, because it could be an invitation to offer where you're able to present your side and present a counter offer in return to present terms that may benefit you in the situation. So let's get into acceptance. Acceptance can be a clear yes. It is you understanding what has been asked of you and you're saying, yes, I want to do this. Now, in law school, we learned the mirror image rule. So the mirror image rule says that when someone offers you a deal, you accept it in the same manner that it was offered to you, like a mirror. If you change any of the terms when you say yes, you're not really accepting it, but you're creating a counter offer. So if someone says that they'll put, if you pay them, they'll put your paintings into a gallery for $500, and you say, yeah, make it 450, and I could do it. You're presenting a counter offer in that regard. So you're not really accepting the terms. It's like in part you're saying that sounds good. However, think about it in this way. I'm offering you this scenario, and let's see if you can accept it that way. So that part, the first now that was the offering party would be the party now trying to accept your new terms to this relationship. So an acceptance to a contract is an affirmation to agree the terms of offer. So it can be written or verbal or shown through action. I always emphasize to my clients that regardless of how the conversation goes, you ensure that you have evidence of the dealings prior to doing any work. Make sure that everything is in writing. If there is an offer, make sure that offer is written to you. If it's an email, if it's a typed letter that is mailed to you, make sure you have evidence of that. In the same sense, if that offer has been sent to you in a letter, you respond your acceptance in the letter. How the law goes that as soon as you send off that letter and put it into the mailbox, that acceptance is confirmed. But I would always definitely make sure that you are accepting in the way that has been offered to you. So when you're looking into the last step, some people don't understand what it means for consideration. Consideration is the exchange. What are you giving up to receive something? So what are you giving up to make this contract binding? And that consideration could be several things. So it doesn't have to be money. For artists and musicians, it could be artwork, performance, music rights, creative services, even a promise not to do something. But it must go both ways. So you have to be wary of what offers of, oh, you'll get exposure. That's very vague. And so remember that in order for that to be a clear consideration, both sides have to give up something. And exposure is not something of value. You have to understand the value that has been given up by each party to understand the consideration. Another thing that I've seen several times is that there are a lot of opportunities to be a part and to enter into agreements, but the gifts are unpaid. You want to understand who is giving, what is that value that that other party is giving up, and if that value and that consideration is not balanced, then you need to come back to the table and maybe provide something to counter what has been provided to ensure that both sides are giving something in value. So a real life example: you create a logo, I pay you $300. Your art is the consideration. Their payment is the consideration. So if anything, if you're not getting anything real in return out of the deal, it might not be a legally binding contract, and you need to go back to the drawing board. So you've understood the offer, you've accepted it, you understand that your consideration to the ordeal, and now you're understanding the other parties' consideration. You have the contract in hand. What's next? Do I sign it? You need to wait to see. You need to read the terms to understand what is present and what your obligations are to the contract. There are several components to consider when a contract has been handed to you. So, the first part, who are the parties to the contract? Know who the parties are. So, for instance, let's say you, as an artist, you have a pen name, you have an artist name, right? Your name is John, but you go by Hugh the artist in the public. When forming a contract with another party, the parties to the contract should be the legal names associated. You don't, and in the contract, you can state that as the artist, your personal name is John Smith, also known as Hugh the artist, to ensure that the right parties have been named and notated within the agreement. You also need to know what are you being asked to do. So, what are those terms in regards to your responsibilities to that contract? Are you creating several different paintings? Are you providing photography service for an hour and a half and being able to produce 200 images? Are you producing a song for an artist and that production should take a few months? You need to know your obligations to ensure that you can agree to them. Is there a timeline to the contract? Are you working in an art collective and having your artwork in a gallery for 4 months to 5 months? Are you working along with a production company providing your services for a year? What does that look like? How and when you get paid? That's important. Is this after the job is done? When was the job determined to be done? And is it monthly? Is it weekly? How much is it? And how is that determined? Make sure those terms are there and expressed clearly so that you understand. And what happens if that payment is provided late? Is there interest that you get from late payment? Is there a way to end the contract if there's a lack of payment or payment in the time that has been requested? And how can you terminate a contract? Where is there a termination clause that gives you options or events that would trigger reasons for either party to terminate a contract? If these parts are not clearly defined, there's some time to negotiate to understand how can we make this contract beneficial to both parties and legally binding for everyone involved. So this is my favorite part. As artists in this industry, and we said your work, your creation, your creativity is the foundation as to why individuals are coming to you. So in this instance, you have to protect the thing that is yours. Protect your ideas, your creativity, your work. Right? That final product is something that you need to make sure that it's always yours. As an attorney at your law firm, I'm looked at as the branding attorney because I'm always telling my clients, your creativity is your work. That is your bread and butter. That is the money that goes into your pockets. If you do not have that proper protection over your intellectual property, someone has the right, the opportunity to take that work and make it theirs. And I've seen since the pandemic, we are in this, I call it the copy and paste era. We see a lot of things out, and on social media, people see those videos, those how-tos, the songs, right, the artwork. They see those things, they love it. So they take them, rip them from whatever source they got it from, place their watermark on it, and say it's theirs. I had a client at one time, around 21. She was a nail tech, and she was also a musician. At the time, she was trying to combine her talents together to ensure that she could have consistent income. So she started to post her videos of her nail art. She started to get a lot of traction on TikTok regarding her nail art and the way that she serviced her clients. In the conversations, I explained to her, I emphasized that you need to be cautious as to how you are performing if you're not protecting your property. Because if someone sees your artwork or they see your videos, they may like it well enough to want to steal those. At the time, she laughed and she was like, well, I mean, it's just nails. Like, who's gonna take it? Within 2 months, she found someone on social media stealing her videos, replacing her audio, adding in her audio, and placing a new watermark saying that new person was the person creating the network. And in that instance, you think, how could I have protected myself? There are several ways. When you think about a contract, you think about, what does that contract say about intellectual property? So when you signing the contract, are you giving away your rights to your work? Or are you giving someone access to maybe borrow or use your work for a period of time? Additionally, a lot of instances where you have independent contractors hired or become hired for other companies, you have artists or logo designers, they're always being hired because of the creativity. In most of those contracts, you'll hear terms of, this is a work for hire. So all your intellectual properties work for hire. That means that the things that you create for the company will be in the possession of the company's ownership. You do not have that authority to claim any ownership, any royalties, any money related to the work that you've created, because the business has stated in that contract that you signed that whatever you do for them, that is the company's property. That's their intellectual property. So they have the right to trademark, to copyright any of that work that you have sent to them. So if that is not something that you wanted to agree to, it's time to have the conversation as to, what do I need to do to ensure I'm not losing my work? Now, one part to consider is an assignment of rights. Assignment of rights is essentially telling someone, the other party to the contract, that, hey, I'm creating this work. However, by this agreement, by me signing, I'm giving up all my rights to the work that I've created, and I'm giving them to you. So whatever I had in intellectual property, my authority to trademark, copyright, or provide a license, I'm giving it to you. We can talk about license in the next slide. So, licensing. The difference with licensing is that you are giving someone a temporary access or permission to use the work that you have created. In several instances, we have licensing agreements. There may be a licensing clause within a contract that provides this particular language. So, in considering the types of services that you provide, as I'm diving, I don't dive too deep, but you're thinking about the differences in how the law is used. So, there is a Uniform Commercial Code, or the UCC. The UCC governs the sales of goods, so like physical artwork. So, with the UCC, um, it, it helps define when the contract is formed, what happens if goods are defective, and what rights both buyers and sellers have. So, if you, as an artist, if you're producing a series of paintings and you're shipping those paintings to a buyer who may be an art gallery, you need to know, how does Uniform Commercial Code apply to this? If I package my artwork, put it in a box, send it off to a carrier, and something happens while it's on that carrier getting to the customer, what happens? Who has the right to get their money back? Would resolve to get extra supplies? What happens in that scenario? You need to consider those instances as to, if I'm an artist, what kind of work do I provide? Do I provide goods or the service? If providing the actual goods, you're looking at the UCC. If providing the service, you're thinking into common law. And sometimes, depending upon what it is, there may be a combination of both types of laws that apply to your contract. However, in that instance, it needs to be clear as to what is applied and how do we go about using these laws in the right way in this agreement. So, when you have a contract, you have it in mind, you're ready to sign. Sometimes, when you have the contract, you don't want to sign it. Here are some red flags that you should be wary of, pay attention to when you are handed the contract. Vague language. I was reviewing a contract for an artist, and it mentioned in the contract a delay because of bad attitude. Don't know why it was in there first and foremost, but what is a bad attitude? Can't define that. You have to make sure that's clearly defined. As we may know what a bad attitude is in our personal opinion, but there's not a general consensus as to what a bad attitude would be. No clear payment terms. So if the document says, oh, you get paid every 3 weeks, how much? What does that mean? Am I getting, if it's every 2 weeks, is that 2 weeks when I get per hour, or is that a flat fee? Are you paying per product? What does that look like? If there's no written agreement, they tell you I got a phone call. They said it, I could do some work for them. Or I can take the pictures, and that'll work out for me. And they'll pay me 1,500 for a couple of hours, and I'll have all these different sceneries. But where are these terms written down so that way we can formalize this thing? Or if there's a work for hire without explanation, if you're walking into a situation where a company is stating that they love your work and they want you to do some things for them, and just if you could just work for them, that'll be great. And then the process is saying, oh yeah, because this is our thing, and we don't, you know, because you made it for us, this is ours. If that wasn't discussed, explained clearly, I would definitely back away. So, and also waiving rights without compensation. There should be no way that you are assigning your rights to a third party and you're walking away empty handed. Remember, when it comes to consideration, there always must be value added to the agreement. You never want to walk away feeling like you have been drained of your time, your energy, your talent, your resources, and the other party is walking away with an abundance of talent and potentially money if they are reselling what you have provided to them. And that is the first part with the foundations of the contract. This is my information on my socials, and I will pass it on to Pete.
All right, Peter, I'll let you introduce yourself and give us some tips and uh, negotiating on how to negotiate once you get a contract.
All right. Thank you, Beth. And thank you, Charles, for getting us going here. I'm Peter Singh, practicing attorney by day, about 10 years out of Duke Law. Professional musician on the side, shoe company owner, kind of involved in the arts all around. And I did start up Carolina Lawyers for the Arts and Entertainment, or CLAY, to serve North Carolina and South Carolina for low cost, no cost pro bono services in the arts. So do feel free to reach out after this if you have any contract questions or other stuff for me. But we can just quickly recap what Charles already presented well. Elements of the contract, some other stuff to consider, and then I'll kind of drill down on what to look out for, mainly from the seat of the artist or the creator, but also just all around. So contract elements, we have offer acceptance, consideration, as Charles pointed out. Some other stuff that does tie into the validity or the enforceability of the agreement is whether it's legal stuff that we're dealing with. So you can have all these elements offer acceptance, consideration, but if it's for a drug deal, that won't fly in court. You can't enforce that. So you do have to be mindful of that. And drug deal was kind of a joke, but not so much. We do have the legality or illegality on the fence when it comes to marijuana, hemp, all those sort of related products. And it is somewhat uncharted territory. So just to be aware, if you are dealing in those spaces, it's a little bit of a Wild West. Capacity, and this is something Charles touched on a bit, in terms of dealing with minors or anyone that might not have the legal right to enter into contracts on their own. One thing Charles mentioned, like with minors, it is a really good idea to have parents or guardians be the other party or the signatory there. If you do enter into contracts with minors directly, it's it's enforceable with an asterisk. So that minor has the ability to void the agreement at their option. So it's voidable by that party. They can enforce it against you, but you can't enforce it against them, which puts you in a pretty bad position. And then awareness is just the other thing. So you can have all these elements. They can kind of be just about there. But if there's any question in terms of sobriety or whether a person is actually acquiescing or agreeing to the terms, then it can poke holes. And we do ultimately want to make sure contract boils down to a deal. You want same understanding walking away from the table with the parties of who owns what, who gets what, when, all the 5 W's and more. So we can move to the next slide. All right, so touching on that, the biggest thing I think to look out for, and Charles spent a good bit of time on consideration. So just the economics, who gets paid by whom, who gets what from whom, how much, when, and touching on if there's a late payment, how that impacts the contract in terms of even whether it's still enforceable or how to deal with that, if it's a penalty or interest rate or anything along those lines. And a lot of where I spend my time is with disputes. So when you're getting a deal done, everybody is kind of honeymoon phase, happy on the front end of things. You think nothing will go wrong. And a lot of these terms are just in case something does. So it's the lawyer's job to rain on the parade a little bit, think through worst case scenarios and how to handle those. One such provision is how to handle disputes if any arise. So besides the practicing lawyer thing, I am also a certified mediator and arbitrator. So the way to deal with disputes isn't always to go to court and sue immediately. A lot of times there's some window of opportunity for the parties to negotiate directly with each other. There's also kind of the next step up is to involve a third party or a neutral that comes in, hears both sides, figures out what's fair, and helps the parties settle. So that's the role of a mediator. An arbitrator is kind of one rung up from there, where they're going to hear both sides similarly, but it's more of an adversarial process. The arbitrator will make a decision for you in terms of an award and say what's fair, who wins, who loses. And then the last step, most expensive, most time consuming, is litigation, where you're in court. The lawyers win because they get paid by the hour or however they arrange their fees, but it does usually drag things out. So you do want your contract on the front end to make sure that that last step is not the first step. You want to leave room for all these other various types of alternative dispute resolution before you're stuck for years and legal bills handling things that could otherwise be handled directly or with a little bit of help. So we can go to the next slide. All right, so liability. This can get really tricky in the art space. So the biggest thing that comes up, obviously, is like Charles said, copycats, infringers, people that are one step past inspired and actually just infringing or stepping on the creativity of someone else. So a lot of times in these agreements, you'll have something called indemnification. The way I break that down in layman's terms is basically if this party on the other side of the deal is hurt or damaged by something that you did or something that's your fault, indemnification is your responsibility to cover them for that. So it's basically if you're a songwriter and it just so happens another song looks and smells and sounds a lot like yours, those writers or their people come after the label in this instance, that label will come after you as the writer and say you should have been aware of this, or did you actually have the creativity or have the rights? So Charles spent some time on licensing. That does factor in pretty heavily on the creative side. If you want to be in the clear, there's something called clearance that you can seek out for creators of stuff that kind of stood as a foundation for what you did, making sure that they either get some upside, some royalty, some fee from what you do with a derivative work, which is something that comes from their thing. So liability is big to look out for. A lot of times it's unfortunately snuck into fine print, like at the end of a contract, which some people call boilerplate terms, or things that people don't look at. Other times you'll see it kind of in big, bold, all caps, which is also psychologically pretty easy to glaze over. But you do want to make sure you look out for the word indemnify. It's also phrased as hold harmless from time to time. But that basically means the economics, which we dealt with in the last slide, those can completely change if you are having to come out of pocket for something that goes awry later. So some ways to avoid that situation are clearly laying out limitations of liability. So you're basically saying, hey, I'm on the hook for this set of things if I'm grossly negligent, if it's willful misconduct, if I'm doing wrong on purpose, or just so careless that something crazy happens. I'm on the hook for that. But other stuff, if I'm just in my zone of genius, creative zone, and happen to create something that sounds like something else, having a limitation of liability is one way where, unless they can prove you were grossly negligent, willful misconduct, then you're not in a position where you have to cover that cost. Another way to kind of hack at that is a liability cap. And what that means is that you basically set a dollar limit of exposure for yourself. So even if you are on the hook, if you were negligent or did it on purpose, you can even word it in a way to where you're not coming out of pocket for more than they've paid you. That's usually the sort of cap we see, or it could even be reduced from that, like the last 3 months of payments if it's an ongoing thing. You do want the other party to have some comfort, some cushion, that they're not going to be left holding the bag or completely on the hook for what you do wrong. But in the same token, you want to make sure that you're not getting into something where everything you've negotiated for, everything you got paid, suddenly goes away because of something unforeseen. So the other way to protect against that is with different sorts of insurance policies. This is more in the weeds, usually with corporate clients and other things, but even in the creative spaces, you can make sure that you're covered by some sort of policy. And really the way I try to make clients think of insurance is basically betting against yourself a little bit, that something does go wrong eventually. You're paying those premiums along the way, in the hopes that just in case there's some backstop there and protection there. So we can go to the next slide. All right. So economics is who gets paid when for what. Liability might come up and kind of mess with that, but the duties are really based on who's responsible for providing services or goods or some mix of those things. One thing that comes up, and this ties back to the liabilities piece, representations and warranties. That's something you might see in these agreements. And basically what they are promises about the work being yours, only yours, promises about not infringing on other people's rights or along those lines. Sometimes in the art space, this is kind of unique to the art space. You can have some obligations of specific performance. So if it's a, a curated piece, or you've been commissioned to produce something and then you decide you don't want to or you can't, specific performance is usually a no-no. Since we've abolished slavery, courts generally don't like to force your hand and make you do something. But if there is a very unique set of skills or very unique style that's yours and only yours, if someone pays for that, just for that, a court might enforce specific performance, which means you have to do what you said you would do, or you give everything back, essentially make them whole as if it was a wash and never happened. You also want to know, in terms of duties, and this comes up in the art space, what your obligations are, not just during the contract and to fulfill the contract, but afterwards. Sometimes there are restrictive covenants, and that can be non-competition, non-solicitation, non-disparagement, all the nons in the world, that say what you can't do in dealing with parties after the fact. So where that can come up a lot of times, if you're, for instance, making a logo for a sports team, they might want to make sure that the same sort of style or color scheme or whatever isn't directly used for a competitor. So they might have some creative control for a limited time moving forward to what you do for other people. I always say, when it comes down to it, any sort of exclusivity people want like that, you kind of have to negotiate that as its own deal separately, because it's not only the cost and the time and the attention to deliver this thing, but it's also the opportunity cost of not doing the next thing that might come to you. So definitely consider post-termination requirements or duties or obligations after the agreement to be something that is okay to negotiate at the table, and make sure that you see the value there, and what you might be giving up. Next slide. All right. So tail end of my piece of this, negotiation tactics, some triage strategies, and some war stories. So in terms of negotiation, part of my approach to that is, as a mediator, I mentioned, kind of walking into the room, sitting down at the table with a good handle on what's important to you. Like, what do you want to walk away from this deal with? It might be a dollar amount. It might not. It might just be the credit for something that you're working on. It might be some upside or position to negotiate for the next deal, next event. So really think through in this engagement sort of what you want to come out of it with, and put that hat on. Do your best to come away with it. One thing I learned in the mediation space is something called BATNA, or the best alternative. It's an acronym for best alternative to a negotiated agreement. So if you can't get that deal, if you can't get that provision, what's the next best thing that you could walk away with? It helps to think through these things before you sit down. But lawyers are also good as a resource if you don't know what to ask for, if it's a new space for you. One, making sure that that lawyer has some experience in that space so they're not guessing the same as you. But we are usually, as a resource, pretty good at letting you know what's market, quote unquote, or what other people have asked for and received in that situation. Letting you know what's kind of odd or out of bounds in terms of what's done in these sorts of deals. And you do want to make sure that you're well positioned in terms of industry norms or standards to some degree. I say that with the asterisk that it is good to get better terms and better deals when you can. I did see over the weekend the movie Sinners with Ryan Coogler and he's made some headlines for getting some outsized rights in terms of reversionary after 25 years, kind of having exclusive creative control of sequels and anything else that comes out of it. So that's not normal in Hollywood, but he had probably some really good lawyers helping him in the mix there. So you do want to know what is standard and also how to deviate from that if you have any negotiating power, any leverage. He happened to have some Marvel movies and stuff in his back pocket that most of us don't. But if you can command any specific terms, it's always good to ask. And the takeaway, this is the last slide, last bullet, I believe, is that this stuff is usually just in case. So again, honeymoon phase, when you're sitting at the table, you think everything will go the way you think it will. But unfortunately, lawyers exist for a reason. A lot of times there are misunderstandings that lead to disputes, that lead to litigation or protracted arguments. And you do want to think ahead in terms of how to address those things so it doesn't take your time and waste your life after the fact. So all told, contracts are deals. They're important in the sense that you want to be on the same page with who you're dealing with. You want to be level set, have the same understanding for what you're getting into. But you also want protections on the other end if there are any provisions that aren't honored, any things that fall apart. You want to have some understanding and protection for what happens then. So with that said, there are some really great resources on the Triangle Arts Works profile. There are two in particular I want to shout out and point out. The Contract Basics for Artists and the Contract Terms Checklists for Artists. If you are getting into anything and you forget what we talked about here, both of those are pretty good primers to just save as PDFs, have in your back pocket, quick reference, and make sure that all of those bullets are kind of addressed one way or the other. Yeah, and I'll turn it over to Beth. I think we have some audience questions and some other things we can get into here.
Yes, we do. And Tiffany, if you could pull the contract information from the resource pages and drop it in the chat, that would be great. I was trying to do that, but I realized I needed to get back on. Yeah, thanks so much, Charles and Peter, for giving us the basics. And we do have some questions that were submitted before, and we'll sort of start with them, and then we'll go to the questions in the chat. And some of them are related. And you all have sort of talked about sort of the basics of the contract. And so I think hopefully now, if someone is talking to you about doing some work, you have an idea of what you need to make sure you negotiate and get down. But the question always comes up, and it came up beforehand, and I think preference is the kind of your question is, do you always need a contract? And does the contract always have to be in writing? And as you said, Charles, I mean, there's, email back and forth. Is that a contract? I mean, so what constitutes a contract? And to preferences question, just like, can you put terms and conditions in an invoice? Will that constitute a contract? That's so if y'all talk around the question of, does a contract always have to be in writing? Do you always need a contract? And what is a contract? I mean, what would be considered a contract?
Yeah,
Who wants to?
I'll take a stab.
Okay, yeah.
I'll preface my response here with the adage that to a hammer, everything is a nail. So to a lawyer, of course, we would prefer a written, signed agreement where everything is clear. And I honestly believe in my heart that helps avoid cost and expense and headache down the line if there are any disagreements about what you agreed to. So for starters, in my opinion, always best to have something written, even if it's simple. But there are other sorts of contracts. There's oral contracts that can technically be legally enforceable if you're able to prove all of these elements. but it is an uphill battle. Like you have to essentially have evidence of each element, and it's much more difficult to hold the other party accountable or responsible for what they agreed to if you're not presenting a signed writing that's very easy to see.
Yeah, to add to Peter's point, for sure, we definitely would agree with having something written, something that you can see. But yes, there are oral contracts. And for me, I always give the "it depends" answer. We learned in law school that the best answer is "it depends." It can depend on the situation. So for artists, it can depend on the type of service or product that you're providing. If this is something casual, if it's a favor, you may not need something formally written. However, if you know you're looking into the details of licensing and giving up rights and things of that nature, most I would definitely go with having something written down to ensure that you have the right to enforce the terms that have been provided to you.
Right. And so to preface this question, I mean, she says that, if you include terms and conditions in an invoice and state that payment constitutes an agreement to those, does that necessarily create a contract? I think that it creates, I guess, an offer to the three elements of a contract: offer, acceptance, consideration. If it creates an offer, if the person pays, that would then theoretically create acceptance. And to y'all's point, it would potentially, give you something to hold up to say, this is what we agreed to. Um, and there's two sides to look at this, I guess. It's the, you want the contract, you want as many terms in writing so that um, you can, you know, make sure you get them enforced and make sure they're in your favor. But there is also you need to make sure you know when you're entering a contract, right? Just like make sure there's someone sends you an email or calls you on the phone and says, will you do this? And then you do it with offer, acceptance, and consideration. You potentially, have a contract. So just know that it goes both ways. And a question we get a lot in these legal programs, and I think it's a great one because we know people who have had issues with this before, is I mean, this has been very helpful in kind of understanding contracts, but at what point do people need to contact a lawyer? And the other side of that is, um, when is it okay to use online legal forms and online lawyers?
Yeah. So I'm a big fan of looping lawyers in early and often. Of course, there's usually cost and expense to that. So it's up to your budget. It's up to uh, whether you feel in your depth or out of your depth in dealing with any given situation. But just anecdotally, like I mentioned, I bought a shoe company. My lawyer for that deal is on the line here, Denzel. So even me, being a lawyer by day in that space, M&A, found it valuable and worthwhile to loop him in to deal with certain aspects of that. So I would say, as soon as you feel like you could use support, use help, demystify anything that you might have questions about, then it definitely makes sense to ask a lawyer that knows that stuff, that's competent in that space. I would say it doesn't usually add a lot of value to ask your traffic lawyer about your entertainment contract. But sometimes it might if they know that for whatever reason. But I say that to say, like, law is a pretty specific field. Most lawyers tend to have experience in their lane and only in their lane. So you do want to be cognizant of that. Not all lawyers provide the same level of support or value for your thing. And one resource like Beth was working on even before me is like a attorney referral list. That's kind of what Clay is aimed to do. Make sure that people know who does what in this region and in these industry spaces. So that's something that should be available soon. I've been saying that for a little while. and hopefully those lawyers listed as referral attorneys on Carolina Lawyers for the Arts and Entertainment are a good place to start. There are a few other resources worth looking at, even just doing online searches for who can handle a matter. So Google always helps get there to some degree. But to the second half of the question, like when to leverage templates or forms or even AI and other resources now, I would say those are great learning tools. It is really good to see what people have done, how they've done it, what they've included, not included. But I'd say that with an asterisk that ChatGPT passed the bar, but it's not licensed yet to represent you. You cannot hold them liable for legal malpractice. So it is good to have an actual practitioner you can hold their feet to the fire for providing you the right advice at the right time. But these other tools, templates, resources are great to learn. And I'm kind of a weird lawyer in the sense that I have an angle toward obsolescence in my career path. I want to empower my clients to understand this deal and how that informs the next deal, and really be empowered to handle things that come up. But to always let them know I'm in their corner just in case.
Yeah, I will say over the years, we have been, as an organization, we've been asked, like, why don't you create a group of standard templates that, we can share out? And for all the reasons y'all have already talked about, which is how each of the elements that you've discussed may change for every situation and every client, or every party, that it's just, we felt that there was no standard, pro artist versus pro, agent, uh, contract. So there's too many variables. Charles, do you have anything to add?
Well, first and foremost, I definitely agree with everything Peter said. I do want to emphasize that we understand. And I know, me personally, I know that Peter understands with his background that things are expensive, right? In this economy, a lot of things have increased. But I think in this process of you paying attention to what you want to do, it's also trying to organize what is the best way to help myself. And in that process, you have to budget across the board. Like you budget for your supplies for your work. You have to also budget to ensure that there is a team close by that in the event that you don't understand, someone that has that knowledge and experience can be there to step in to help you. Because that's our goal. I think Peter's talked about, like, we want to empower our clients to ensure that they understand what they're signing. Every contract that is handed to me, I'm walking line by line with my clients to understand, to help them understand this is what the contract is saying. This is what it's requesting of you. Do you understand? And you can't get that all the time with certain AI tools. Yes, they're great as resources, but as far as the end all be all, using them to create a contract, I would steer away a bit.
Yep. Okay, we have a couple more questions. Just gonna get them in real quickly. One of the questions that was submitted was, how do you deal with if you are an artist who goes by a separate name than your, I guess, real name? I don't know what's that, but how would you do that? How would you handle that in a contract?
My method is usually to use your full legal name, but then there's something called a PKA, or professionally known as, or AKA, also known as, and then you can use your stage name for reference there. But in order for the contract to be binding, like, it has to be an actual there as the other party. So not just the fictitious name, but also the actual legal name should be used.
Yes.
Yep.
And there's another question submitted. I'm sorry, Charles, did you have anything to add? No. Yeah. Marianne, you submitted a question and it says the offer should be by the producer, offer by the producer be signed before we signed it. I'm not sure. Do y'all
I
understand that?
know, it really wasn't written well. And it was regarding something Charles had just said about when the contract is submitted, and before you sign it. And I always feel like I'm no spring chicken in all this, but if someone's submitting a contract to me for my consideration, I want their signature on it first. It rarely happens, but in this case, is that what you were saying? They submit a contract, they sign it, and they wait for my signature. Is that right?
Well,
Maybe yes, maybe no.
right. It depends on the the situation of how it's presented to you. I've seen it in both ways, to where the contract has been provided to an artist and it has been signed already, or you get the contract to review first, because how it starts in the process, it's a negotiation stage. So
Oh,
I would go out in the beginning, having anyone sign the contract. We're negotiating in the beginning to ensure that my client understands the obligations and responsibilities to that contract and what happens once they sign it. So in that process, there may be conversations, and then we can talk about if we're in the same room, we're signing it at the same time.
so in my case, if I were going to hang my art at a gallery for the first time, which I'm hoping someday, the gallery probably is prepared with contracts that cover liability and all of that. And I would have to make sure that I have insurance too, don't I? That indemnifies me, as you were saying,
I
from the
definitely.
obligation.
I'm sorry, you cut out on the last part. What were you saying?
I said I would also need to have insurance, professional insurance, that would indemnify me, hold me harmless for whatever reason, though it doesn't seem like there's anything they could sue me for, but perhaps someone would come in and say I copied their art.
I think a lot of that would depend, and y'all can jump in too, but I think a lot of that depends on what the contract says. And that's, as Charles and Peter have said, that's what you need to look at. It said, see what it says about indemnity, liability, and then anything that you're accepting, then you need to, as Peter said, make
Yeah.
sure you have covered some way.
Well, what if they don't offer you a contract? Are you then under liability I mean, is it your responsibility then? I guess, yeah, they would have to do the contract, wouldn't they? Or you would suggest an agreement of some sort.
Yeah,
Okay.
for
I'm all in the
galleries,
business, so I have a billion questions.
yeah, I love them.
And for these reasons, I have put Peter's Clay, which is the Carolina Lawyers for Arts and Entertainment, put their website in the chat, and also Charles's firm, we'll put in the chat. So if y'all need to follow up.
Thank
Go
you
ahead,
very much.
Peter. You were saying something.
Yeah, just it would kind of be situation specific. Some galleries are kind of ready and equipped with their own forms, but they could be a startup, much like some artists are. So not everyone's kind of in the same position in terms of what they're ready to provide or have. But if it is a first deal for them, first deal for you, a lot of times a lawyer can provide a good usable agreement for this situation and beyond, and that might help them moving forward as well.
And we had one more question. I think we can make this the last one because we're kind of out of time, but it's a question about conflict management, best practice for conflict management when working with artists. I mean, it says, is there a twist to it? And I guess the question would be, it doesn't say, but whether when there's a contract or not a contract, but any thoughts on conflict management?
Yeah, that's kind of my domain a little bit. So disputes, conflicts, misunderstandings, those are kind of unfortunately usually part of a deal. Even if you have very clear written terms, sometimes people have different understandings of one provision or definition or what's not written or said. So conflict management, I think, is pretty important to bake into the agreement, to the extent you can, have a dispute resolution section that says how things are dealt with, how they escalate if necessary. Absent that, it is much more difficult to deal with things once there is a fracture or disagreement. You can't agree on how to address the disagreement. So that is definitely something I suggest, a ground that you cover on the front end when things are hunky-dory. It is much easier to say what if, just in case, how we address these things as they come.
Yes. Well, thanks very much for that. And I see that Tiffany is dropping information for both of our speakers today into the chat, so you can follow up with them. And as we said at the beginning of the session, this will be online. You will all get an email when it goes up on Archwell TV, our YouTube page, and while you're on the YouTube page, you can see all the other great programs that we have recorded on there. I want to thank very much. I want to thank Charles and Peter for giving their time today and sharing their knowledge with us. It's been really great and very helpful. You will also be getting email with the survey where we only do as well. We don't have. I can't talk. We only do well if we're actually impacting you and creating good programs. And the only way we find that out is to hear from y'all in surveys. So please answer the survey and let us know how we're doing, and also put in there what other programs you would like for us to create. Know that I'm assuming Tiffany, when she sends you the email, will also tell you other programs we have coming up. I know our tax program, I think, is next week. We have an SBA program, talking about what programs the SBA has for artists. And then I think we're already registering for our fall program. So Tiffany, do you have anything else to add before we close?
No, I think you've I think you've covered it all. We will send an email, follow-up email with the survey and any additional information, as well as advising everyone, all of the registered participants, that the information is up on our YouTube channel for you to view and share with your network as well.
Yes, perfect. Thanks to everyone. Thanks, Charles and Peter, and we'll hope to see you all at another event.
All right. Thank you all. See you.
Thank y'all.